Hey, what's up guys? This is Ben from Cut Law. Today I'm going to talk about restraint of trade clauses, also known as non-compete clauses. What are non-compete clauses? I'm sure all of you have seen employment contracts before where they say, oh, after you resign or after we fire you, you cannot work for a competitor for 2 years, okay? You cannot open your own business in a competing industry, you cannot do this and that. Now, to cut it short and sweet, okay, non-compete clauses are generally unenforceable and void. Why is it unenforceable and void? Simple reason, public policy. Employers cannot try to control or prevent their ex or former employees from earning a living, okay? Now, there are certain circumstances where the Singapore courts, okay, after the employer sues, of course, sues the employee, there are certain circumstances where the courts will uphold the non-compete clause, okay, and actually grant an injunction to stop the employee from working with a competitor. Now, when will non-compete clauses be recognized by the courts? Firstly, the employer has to show that he has a legitimate proprietary interest. What is a legitimate proprietary interest? The employer has to show that the employee has confidential information, trade secrets, customer lists, supplier contact lists. These are legitimate proprietary interests that the employer is entitled to protect, okay? After he has cleared this hurdle, okay, he still has to prove to the court that the non-compete clause is reasonable, okay? There are 3 hurdles he has to go through. First, he has to satisfy, the first hurdle is geography. How wide is the clause? Is it worldwide? Is it Singapore, Malaysia? Is it Singapore, Malaysia, Thailand, UAE, in the US? That's too wide. You're preventing the employee from working in so many countries. If it's in Singapore, it can be just Singapore alone, it can be argued to be reasonable. But it would be best if you circumscribe it, for example, 2-kilometer radius within Orchard Road or Paragon, for example. The next hurdle that the employer has to overcome is width of the clause. How widely drafted is the clause? The courts will not recognize a widely drafted clause. For example, you cannot work for a competitor in the same industry. That's too wide. What is a competitor in the same industry? If a company sells milk and then suddenly it decides to sell fish, planes, cars, or what, it's too wide. It has to be very specific. The width has to be very narrow in order to be reasonable. The third hurdle that the employer has to show the court that is reasonable is time. Okay, how long is this non-compete restraint of trade clause going to bind the employee? Okay, the courts have held that generally 9 to 12 months, okay, is a reasonable period of time. Anything more, for example, 18 months, 2 years, is unlikely to be enforceable. Okay, so what I've said just now applies to the employer-employee context, okay? But restraint of trade clauses, okay, in the context of a sale of business will generally be upheld. Why is this so? Because when you sell a business, you don't want the seller, the former owner of the business, to open at the same business and compete with you for revenue. So an exception is the sale of business, which is to prevent, after making millions from selling a business, the former owner go and open the same business, to the buyer's detriment. Okay, so that's all we have today. If you like this video, please click subscribe. Thanks for watching.